the Virtual Center for the Study of the Constitution and Civic Responsibility, an ongoing inquiry into American political origins and evolving institutions. The Executive Director of the Virtual Center is Dr. Bill O'Brien. He's also your host for this conversation. Here he is now, Dr. Bill O'Brien.
Thank you, Bob Kincaid, and welcome to another week here at the Virtual Center for the Study of the Constitution and Civic Responsibility. We have reached the halfway point in the month of June. Today is Monday, the 15th day of June in the year 2014. It's hard to believe that 15 days from now we will be moving into the second half of the year 2015. It seems like it takes half a year to get used to the change in dates and writing checks and those kinds of things, does it not? It is a pleasure to be with you today at the start of a new week. Hopefully it'll be an informative one and an interesting one, especially for you, but also for me. And in order for that to happen, I need to hear from you, as we did in our last program on Wednesday when we got a call at toward the tail end of the program from our friend Horzak in Horst in Taiwan. Our phone number is area code 304-663-4676. 304-663-4676. My email address, if you'd like to communicate directly with me on some of these issues, and we'll kind of get into a little bit of review in a moment, my email address is waobrien906@gmail.com. W-A-O'Brien, O-B-R-I-E-N, 906@gmail.com. It is a pleasure to be with you on a Monday, and looking forward to a new week of programming and discussion and hopefully conversation here at the Virtual Center. I look forward to hearing from you. Our focus over the last week and a half, 2 weeks of programs, it seems to me, has been precipitated by an article that we looked at from the Chronicle of Higher Education a couple of weeks ago entitled The Attack on Truth. And we have pursued a number of issues or a number of avenues of perspective in looking at that issue. I kind of thought on last Wednesday that we would probably be done with that issue, but lo and behold, it seems like some of these things are so complex, so involved, that you're never really done. So I hope, I keep thinking back to when we were dealing with those who left, the people who left Amoros, the short story by Le Guin, if you remember, Ursula Le Guin, some time ago. We spent so many programs on that particular short story that I did receive a couple of emails saying, you can't possibly have anything else to add to that particular thing. I kind of felt like maybe we just dwelled on that one, but maybe just a tad too long. I hope we're not guilty of that same thing again. I don't believe so. As I was putting together my thoughts and my ideas for today's program, it became very clear to me that we are indeed not done with this issue, that there's quite a bit more that it seems to me we can focus on this issue, and especially since it's been 5 full days since we've been together here at the Virtual Center. I spent some time toward the end of the week last week, I believe it was on Friday, and I was thinking about our programming for this week, and I was trying to make some decisions as to which direction we ought to go in. And the first thing I thought about was maybe I ought to begin Monday, which is right now, with a kind of an overview or a review of where we've been and what I think we might have accomplished in covering this topic about the attack on truth. And of course, you'll recall that so much of our information and our insight on this particular issue we owe to one of our listeners, Harry, who's located in Baltimore. And I've I've tried to make it a point in each program to thank him because the material that he's given us is absolutely astounding. It's been an education for me. I hope that you have learned from it as well. And I tried to be to express my gratitude to Harry for this. But as I mentioned in our last program, I had to ask Harry where his expertise on this particular issue came from. And Harry shared with me his long-term interest in this program, his long interest in the issue of science. He shared with me a number of personal things about his upbringing and his interests in school and many of the friends he had and various other things. The point is that for a number of different reasons, coming at this topic from a number of different directions, Harry became absolutely an immense resource on this particular issue, and he's been kind enough to share many of those sources with us here at the Virtual Center, and I am so grateful for that. And again, I have to believe, I hope, that those of you who've been listening regularly have found this information, this topic, both interesting and informative and necessary. I know that I have. My particular interest in it began principally from the perspective of history and philosophy, because that's where my background is. And, the combination of not only history and philosophy, but also political science, looking at the founders, looking at the nature of the constitutional system, as we've done here for close to 2.5 years here at the Virtual Center. I was particularly struck, and just as part of this review, I was particularly struck by first of all, the irony of the circumstance that in the middle of this particular issue here at the Virtual Center, I believe on Thursday, and I may be wrong on the date, but there was an article in the Chronicle of Higher Education by a historian and philosopher named Ted Gupp, G-U-P. Ted Gupp teaches philosophy at Boston College. He's written several books on the study of history and the importance of the study of history. He's a historian as well as a philosopher. He's a scholar of the history of history, if that makes sense. And he wrote this piece in the Chronicle a few days ago, which seemed to tap into my particular interest in this topic, and this is what first got me interested. This is before Harry came forward with all of these other resources, which he has been kind enough to share with us here at the Virtual Center. Seems to be some interference here, excuse me. Anyway, Ted Gupp wrote this article in the Chronicle dealing with the issue of the attack on truths. And basically, I'd like to read just a couple of excerpts, a couple of lines from Ted Gupp, because I think what you'll begin to see is where my interest in this particular topic comes from. Mr. Gupp says the following: day after day, the news is filled with conflict, not over what is, but what was. The past proves to be as inflammatory as the present. The past is never dead. It's not even past, observed William Faulkner. In grade school, we learned history was composed of accepted facts and dates that neatly yielded to true and false quizzes. As adults, we discover history to be utterly fluid, a changeling that spurns hard facts and cold truths. Far from the calm reflecting pool presented to us in youth, we now see it as a cauldron of resentment and recrimination. History does not resolve, it festers. And this is his perspective. And what he basically, of course, is talking about is the extent to which people have a tendency to use history in order to support or to back up their own particular agenda, be it political, be it economic, be it social. And that's his concern. And he points out that the different directions that we seem to go in different eras and the way we study history seem to reflect not only the importance of the discipline, but the importance of being able to get a firm grip on exactly what history can teach us and what history does not do for us. And of course, the fact of the matter is, history does not prove anything to be a hard and cold fact in terms of argumentation. Because so many people try to use history as they go about, and I've used this term many times, cherry-picking the evidence. In other words, they have a particular point of view or a particular thing that they want to prove. And they go back into the sources in order to find evidence that what it is they want to argue or what it is the case they want to make, they're looking for evidence to support that. In the process, they tend to discard or to put aside all evidence that contradicts the particular agenda or the particular point of view that they have in mind. And so consequently, people have been able to use history to pretty much back up whatever position they want to. It's a disservice to the discipline. And it's something that I've emphasized more and over again here at the Virtual Center in previous months. And I think Mr. Gupp Ted Gupp is very, very much on target when he talks about the traditional classroom approach to the teaching of history. We basically felt that we could rely on the facts. And so consequently, we tended to make our history courses lessons in the parade of facts. Usually the only thing that connected one fact to the other was chronology itself. This happened, then that happened, then this happened, then that happened. But the perspective or the issues or the insights that help explain why a particular thing happened or didn't happen, those are the issues that we've been reluctant to allow students to get into. But our political leaders and those who would inflame public opinion, and notice I didn't say inform, I said inflame public opinion, behind a particular point of view, began to use history, and that's what Ted Gupp is referring to here when he talks about the past being fluid and changing. And his concluding line that history does not resolve, it festers. He said, these days I'm left to wonder what remains of history, what can be trusted of a past that is forever at the beck and call of a self-serving present. Is anything indisputable? He asks. And then he goes all the way back to the very beginning, and I think what I mean by the very beginning is 2,000 years ago, Herodotus, who, as we know, is referred to in Greek history as the father of history. Ted Gupp points out that Herodotus was also known as the father of lies. And what the author, Ted Gupp, points out is that increasingly history is being used to hijack the headlines. People are going back to the founders. The Supreme Court is going back to the founders in order to justify decisions. Whether, in fact, what they are saying about the founders is valid or accurate or not, I would suggest is the key. This is Ted Gupp's point in this article. This has been the point that I particularly, I believe I've been laboring on, if you want to use that term, if it's appropriate, for a long time. You'll recall that when we were looking at the issue of the Second Convention under the Fifth Amendment, the Second Constitutional Convention, we were pointing out the extent to which history and the background of the founders has been used in order to justify some of the changes. We look carefully, for example, at Federalist number 85 by Alexander Hamilton, and his position on the dangers of a second convention. We also know that the initiative behind the movement for a second convention at the time of ratification was being led by those whose purpose was to undermine the Constitution itself, which had already been ratified. We know that Madison began to support a Bill of Rights, amendments to the Constitution, in order to undercut and short-circuit those who were using the lack of a Bill of Rights, as justification for an initiative to call a second convention. And both Madison and Hamilton were firm believers in the fact that if you ever took what was accomplished at the Constitutional Convention and put it back on the table for discussion, chances are that all that was lost through debate and all that was won through debate and compromise would become vulnerable and liable to be lost. Ted Gupp goes on and says the following: society appears to be in the midst of some sort of tectonic shift from a culture that identified certain bedrock facts, the historical canon, as it were, to one rooted in evidence, which is to say that those renderings of the past that support an argument, be it religious, ideological, scholarly, or nationalistic. Even the word facts is cushioned by quotation marks. The abdication of a fact-based study, or its evolution into a nuanced and inquiring discipline, is lauded as a step toward enlightenment and universal enfranchisement. Those who still speak longingly of facts as sacrosanct risk being seen as parochial, short-sighted, and naive. Throwbacks to an earlier and discredited regime. History is now a cafeteria. Take what you like, leave the rest. I think what Ted Gupp is talking about there and criticizing is the shift in emphasis away from the facts approach to the teaching of history into something that is focused on the ability to argue a particular point of view and to garner evidence to support that point of view. This is something that I have been an advocate of here at the Virtual Center. This is something that Ted Gupp is criticizing. If I can, let me try to explain the difference between his position and mine. I don't think we disagree at all. What Ted Gupp is criticizing is the fact that the emphasis on argumentation over fact has caused an overshift away from the facts into the idea that if you make a successful argument to support a particular point of view, then your point of view is as good and as valid as anybody else's. Gupp is critical of that particular approach. So am I. In order to defend the idea of an emphasis on the ability to argue a point of view, we must first make sure that there's clear understanding as to the difference between fact and opinion. We also have to be on the lookout for those who would cherry-pick the facts and give us only the information that supports the particular argument being made, strategically overlooking or ignoring evidence to the contrary. If those two things are accounted for, in other words, if we are sure that the evidence being used to support an argument is indeed evidence, if it is based on valid research, if it is based on a critical look at the evidence, pro and con, for and against, and if the conclusion is supported by valid evidence and a valid interpretation of that evidence, this is good history. But if that argument relies on cherry-picked information, then I suggest it is not. It is not good history. I think Ted Gupp agrees with me. So we both agree. His concern is that the emphasis on making a good argument has effectively bastardized the discipline of history, and I agree with him. It has basically led to the idea that history can be whatever you want it to be. It can say whatever you want to say. As he said, it's a cafeteria. Take what you want and leave the rest. That is invalid. It is dishonest. It is unethical. And that's what we've been talking about in our recent programs here at the Virtual Center under the heading, The Attack on Truth. What we've been pointing out is the extent to which those with a vested interest, whatever that interest happens to be, have been more than comfortable to manipulate and cherry-pick evidence in order to support their point of view. As we'll see in our program today, it gets even worse than that. Because not only do we see those who would cherry-pick the evidence and manipulate the evidence to their own advantage, what we also see are examples of those who would seek to refute hard evidence by demeaning or discrediting those who provide or bring to the fore that evidence. We saw this in science. In other words, the way you discredit scientific evidence is to discredit the person or the methodology that produced those facts. The thinking is you can't come up with enough hard evidence to refute evidence of honest research, because by definition, honest research means that the scientist, the researcher, has covered the lot, has weighed all the existing evidence before he or she has put forth a conclusion which then the researcher defends with the evidence and with the research. There's no way in the world, if those hard facts, if that evidence, the result of legitimate research, criticizes your agenda, there's no way in the world that you can find enough hard evidence to refute that. So consequently, the strategy is you don't need to do that. All you need to do is find flaws in the methodology or find kinks in the armor to raise questions or doubt about the validity or the credibility of the person doing the research. And if you can do that, then you come up with a few opinionated positions on your own behalf. And what you have effectively done is create confusion. You've basically raised the question as to whether in fact we can even know what's real and what's not real, what's fact and what's fiction, what's truth and what's untruth. In other words, what you are doing is not only creating doubt, but you are creating controversy. And in the memo that we looked at last week put out in the Tobacco Wars by Brown and Williamson. The memo that begins that doubt is our product. That's the issue. What you are doing is creating doubt. Doubt creates confusion. Confusion in the mind of the general public creates a sense that it's impossible to know what's real and what's not real. So consequently, the only option we have is to look for the best case, the best argument. In other words, to go back to what the ancient Greeks termed sophistry. The best argumentation, the best debaters, the best use of rhetoric. The people that can make the best argument on their feet, if you will, or on paper, tend to win the day. Since the general public, the audience, can't really distinguish fact from fiction because there's been enough doubt and enough complexity and confusion created to totally confuse those who would judge the debate or the argument. And consequently, in the mind of many people, fact and opinion become indistinguishable. Or more to the point, many people are very, very adept at making opinion appear to be fact. And if you do that to those who are uncertain as to how to identify fact anyway, then opinion successfully in their minds becomes fact. Consequently, if you make a polished, highly skilled argument substituting opinion for hard evidence, you have as good a chance as not to win the day. That's the position, that's the argument, that's the case that we were looking at last week. That's the review. So I think while Ted Gupp's argument is very significant and very enlightening in the area of history, we need to thank Harry for information in the area of science to point out that this is not new, and as Harry pointed out, this is not something that began with the tobacco wars in the 1990s, 80s and 90s. This is something that goes all the way back into the 19th century, where what people are prone to do, want to do, is to cherry pick evidence and manipulate opinion in such a way that it appears to be evidence. And the way you sell it is to confuse your audience to the point that they find it extremely difficult, if not impossible, to distinguish evidence from opinion. That's one of the themes, it seems to me, I know that I've emphasized a number of times when we've been talking about education, is the ability to teach students how to distinguish fact from interpretation and opinion. Now, in the abstract, that sounds like it might be not an overwhelming challenge. But in the real world, where people are trying to pass off opinion as evidence, it becomes very difficult. I think what we have then is a realization as to not only how difficult this process is, but also how important it is. Let me go back. I mentioned the Brown and Williamson memo. We read this last week, and I wanted to share it with you again. This is a memo from a marketing executive for Brown and Williamson Tobacco Company named J.W. Burgard. And this is a memo that was written in the early 1970s in a presentation to other tobacco executives, all of whom feel that tobacco is under attack. This is what Burgard recommends to his tobacco colleagues. Doubt is our product, since it is the best means of competing with the body of fact that exists in the mind of the general public. It is also the means of establishing a controversy. Within the business, we recognize that a controversy exists. However, with the general public, the consensus is that cigarettes are in some way harmful to health. If we are successful in establishing a controversy at the public level, then there is an opportunity to put across the real facts about smoking and health. I would, of course, raise questions about the term the real facts. This is their facts contradicting the so-called body of fact which science is producing about the dangers of tobacco. Doubt, he says, is also the limit of our product. Unfortunately, we cannot take a position directly opposing the anti-cigarette forces and say that cigarettes are a contributor to good health. No information that we have supports such a claim. There's no way in the world we can counter the negative evidence with positive evidence because it doesn't exist. So the only alternative we've got is to raise doubts about the hard evidence. And with those doubts, create a controversy. And the whole idea of controversy is confusion. And the general idea is, as this memo says, right now, the general public believes they know for sure that tobacco is not good for your health. We've got to generate controversy and disagreement about that. And once we do it, once we get the general public unsure of what the facts are, because they'll be unable to distinguish between the scientific evidence that's already been presented and the counter evidence that we'll be presenting, which is not hard evidence as much as anything else. It's loaded evidence. It's evidence that has been cherry-picked to support our case and refute theirs. The result is going to be controversy. The result is going to be two sides to the same issue. And once you create that, then the general public becomes uncertain as to which is the right way, which is the factual way. Consequently, the most persuasive argument wins. At that point, fact and opinion become indistinguishable. And we win. Burgard's memo goes on. Truth is our message because of its power to withstand the conflict and sustain a controversy. If in our pro-cigarette efforts we stick to well-documented fact, we can dominate a controversy and operate with the confidence of justifiable self-interest. If we can dominate a controversy, how do you dominate the controversy? By saying what it is you want to say more often than the other side and louder. You win controversy by demagoguery. By asserting your point of view so firmly, so often, and so loudly that you force those on the other side to back off or to back down. It's not that they're going to begin to question their own evidence because they're scientists. But as far as the general public is concerned, they will be enmeshed in controversy or confusion. They won't know one thing from another, opinion from fact. And if that happens, you win and hard science loses. After our last program on Wednesday, I spent some time thinking about this on Thursday, and the more I kept thinking about it, the more important I began to realize what we've successfully been able to do here in the Virtual Center is important. It needs to be written down. It needs to be put forth for the general public. So basically, I made the determination over the weekend to make it my challenge to try to make this argument, put this argument in writing, and hopefully get it published out there. Because I think what we're saying here is incredibly important. So in my mind, I began to put together what I believe would be a success, and I'm pulling my notes and materials together here, if you'll just bear with me for a moment. It seems to me that we have the makings of a pretty good, solid argument here in order to point out the logic of this particular point of view. It seems to me that a key in the Brown and Williamson memo, while most people put their emphasis or focus their attention on the issue of doubt is our product, most people look at that particular phrase as being the essence of that particular quotation. I would suggest to you that it may be that the real effort, the real emphasis, the real essence of that is not so much the doubt as the controversy that the doubt creates. Because controversy creates uncertainty. And what you're after, if you're trying to counteract hard evidence, especially scientific evidence, what you're after is to confuse the general public to the point that they are unable to distinguish opinion from fact. Once they do that, then your opinions and your ability to put forth those opinions in a persuasive way has the best chance to be successful. It becomes very hard to refute you because most people are unable to distinguish between fact and interpretation. So I'm suggesting that maybe the key emphasis in that quotation is not so much the doubt as the issue of controversy. But there's a third item in that quotation that I would share with you as well. And the third item is the ability to dominate the controversy and operate with confidence of justifiable self-interest. In other words, the side that wins controversy is the side that can assert itself the loudest and the most often. Consequently, it hit me when I was thinking about this over the weekend that this really is the key to the threat posed by Citizens United. Because by allowing unlimited private interest money into our election process, into our campaign system, what the court has in effect done is give self-interested parties in the debate, under the name of free speech, the ability to assert their point of view more often and louder than anybody else. In a sense, then, what Citizens United has effectively done is put on steroids. The efforts of self-interested groups to create controversy and confusion by attacking science, attacking fact, attacking truth itself. Let me stop for a moment here. There's no question that the general opinion, the general thinking about Citizens United, the decision rendered by the Supreme Court in 2010, in January of 2010, most people believe that it was a horrendous mistake on the part of the court. Most people believe that Citizens United was a bad decision. Most people believe that it's going to allow money to buy elections. It's going to allow politicians to buy access to political leaders. It's going to foment and to strengthen the insidious relationships between those private interests who would be regulated by government and those agencies and individuals within government who would do the regulation. In other words, it takes what clearly is a relationship and turns it potentially into an insidious relationship. That, to many people, is why Citizens United, they believe, is a bad decision. I don't disagree with that. But what I do believe is that even more danger to Citizens United is the role or the influence that it will play in the public controversy, therefore, i.e., the confusion between fact and opinion. It's going to make it possible for interest groups, well-funded, well-financed interest groups, to assert their position in controversy so frequently, so often, and so loudly that they will literally bludgeon the general public into accepting their interpretation of fact. And again, it's going to poison the positive potential of the relationship between private sector and public sector. It's going to make it more and more difficult for government to take positions opposed to self-interest in the name of the public interest. It's going to make it more difficult for government and government's agencies to look out for the best interests of the general public in the face of the unending loud voice of self-interest. Let me point out to you that this is not a new phenomenon. Historically, we can basically trace the origins of this. Within this nation, in its history, let me give you a couple of examples of what I'm talking about. In the early 1960s, a historian named Gabriel Kolko, K-O-L-K-O, did a dissertation, a doctoral dissertation, a PhD thesis at Harvard. When he finished his dissertation, it was published. The title of the book that came out of his dissertation, out of his research, is entitled Railroads and Regulations, 1877 to 1916. Basically, what Kolko has done by looking at the evidence and doing the research and the digging is point out that the traditional approach to government regulation of railroads, which in 1877 led to the creation, did I say 1877? I believe it's 1887, led to the creation of the Interstate Commerce Commission, a government agency, permanent government agency, whose responsibility was to regulate commerce. In the late 19th century, railroads. In the process of compiling his research and drawing and presenting his conclusions, Gabriel Kolko shows a pattern of interdependence between economic and political power in America that set a precedent for government's regulation of the economy. What Kolko's research shows is that the relationship between government and the private sector, the relationship between government and the behavior of railroads that led to the creation of the Interstate Commerce Commission, the passage of the Interstate Commerce Act creating that commission, and the permanent role for government in regulating interstate transportation that went from one state to the other. The assumption, the recognition being that if the transportation is wholly within one state, it's a state function and it's up to the state to regulate. What Kolko's research points out is that the relationship between government and railroads, which produced the Interstate Commerce Act and led to the creation of the Interstate Commerce Committee, turned from an emphasis on the public interest. The public interest was for government to step forward and regulate the behavior of railroads in order that those who utilize the nation's railroads would be treated fairly and equally under the law. That's the general interpretation of the Interstate Commerce Act. What Kolko points out is that the political and economic relationships between regulator, government, and regulated, railroads, was a bit more complicated and a bit more insidious than we've ever known. Specifically, what Kolko points out is that railroad attorneys were directly involved in the passage of the Interstate Commerce Act. Let me be more specific. The attorneys for the major railroads, which was the object of regulation, those attorneys wrote the Interstate Commerce Act. They were instrumental in what it said. They were instrumental in deciding what government under the Interstate Commerce Act, what the Commission could do and what it could not do. In effect, then, Kolko points out that what it does is establish an interdependence between government and the economy, which has been perpetuated and refined ever since. That whereas it appears that government is the enemy of the private sector, what Kolko's research pointed out in Railroads and Regulation is that government regulation became the best friend of the railroads. It established secure, stable rules of behavior. It drove competitors out of business. It locked up the transportation business at the time for the people with the most money and the most clout. The Hills and the Vanderbilts, to be specific. And it set the tone for the relationship between government and business, which continues to this day. A most recent example, not the most recent example, but a recent example, is the recession of 07 and 08 and the behavior of government under the presidency of Barack Obama to try to rein in the abuses of Wall Street. We know, because the media is telling us all the time, we know that in spite of the fact the large banks and Wall Street investment firms were principally responsible for the recession because of their behavior and because of government's unwillingness under the Bush administration to regulate the behavior of the financial community. We know that those who caused the recession did not see one leading official in it go to jail. We saw Madoff go to jail, of course, because he duped his clients in what we now recognize was a Ponzi scheme. But in terms of those who were most directly responsible for creating the recession and causing damage to tens of thousands, if not millions of citizens who saw their retirement savings whittled away, who in many cases lost their homes because they had overpurchased inflated assessments, appraisals on homes. It was made possible for people who couldn't afford the payments to purchase homes way above their ability to pay, knowing full well that they would lose that property and it would revert back to the lenders almost free. But nobody ever went to jail for it. I think I did a program here at the Virtual Center some time ago, probably a year and a half or 2 years ago, on the South Sea bubble in the 18th century. The same thing happened in England in the early 18th century. The complicity between those who were investing in private sector people, financiers who were investing in overseas colonial expansion and trade, were able to establish insidious relationship with members of parliament, with the British government, and were able to sell inflated stock. Once the bubble burst, the investors were wiped out. But history tells us that in the South Sea bubble situation in the early 18th century in Great Britain, nobody went to jail, even though many people were ruined. We see the same thing in the recession of 07 and 08. It's very hard to rectify or to understand the distinction, the allegations of critics that Obama is a socialist, when President Obama has made it possible for the financial sector on Wall Street and the big banks to make absolutely astronomical, obscene profit because of their insidious relationship with government and government agencies. I think what we have here is evidence as to the extent to which this problem, this danger that we've speculated about is in fact true. Let me take this one step further, if I can, before we take our top of the hour break. And some of this is review, and it's not important, but I'll make the point anyway. As many of us know, the Citizens United decision was rendered by the Supreme Court in January of 2010. The majority opinion was written by Justice Kennedy. It was 5-4. Besides Kennedy, others in the majority of 5 were the traditional foursome of conservatism on the court. Chief Justice Roberts, Justice Alito, Justice Clarence Thomas, I feel like Rick Perry. I can't remember the last one. I'm drawing a blank here, but I'm not on national television, so I guess that's okay. But what is interesting is the history of the background of the Citizens United decision. Justice Roberts allowed Kennedy's opinion in this case to become the majority opinion. Because in the first round, the year before, when the Citizens United case came before the Supreme Court, Justice Roberts wrote the decision. And his decision was the same, but it was very narrow. Basically, what Justice Roberts was focusing on was the allegation of the litigant, Citizens United, an organization, a private sector organization funded by the Koch brothers, that wanted to put out a video about Hillary Clinton within 30 days of the election of 2008 as a way to attack the credibility and the candidacy of Hillary Clinton. Citizens United took the case to the Supreme Court, lobbying for its right to run the video. Justice Roberts wrote the majority opinion, arguing that this was a free speech issue and it took precedence over campaign finance limitations passed by Congress. Justice Kennedy wrote a concurring opinion. But Justice Kennedy's concurring opinion was much broader in its influence than Justice Roberts. And the majority of conservatives on the court went along with that. So consequently, when the case was re-argued and came back and reconsidered before the court in January of 2010, Roberts backed off and let Kennedy's concurring opinion become the opinion of the majority on the Supreme Court. It's a rather direct opinion by Justice Kennedy. It's 30 pages long. Justice John Paul Stevens wrote the principal dissenting opinion in Citizens United. His dissent, as we looked at some time ago when we covered this here at the Virtual Center, Justice Stevens' dissenting opinion was 3 times as long as the majority opinion. It was 90 pages. And what Justice Stevens did in his dissent was to go all the way back and look at the history of the First Amendment, look at the founders, look at the tradition, the historical tradition of Congress's right to regulate campaigns and contributions in order to protect the purity and the sanctity of the campaign system and the electoral process in this republic. Basically, what Stevens' dissent concludes is that the majority opinion written by Kennedy was not the correct decision for a number of reasons. It ignored evidence. It ignored precedent. It denied the things that it didn't want to take seriously. For example, the major one, that money corrupts the election process. In this decision, Justice Kennedy stated affirmatively that there's no evidence of quid pro quo buying influence evident. In other words, while it's alleged, and while Congress in the past acted as if it was a fact, the fact of the matter is, Justice Kennedy pointed out in the majority opinion that there's no hard evidence to support the allegations of opponents to the Citizens United decision that money corrupts the process. In other words, in order to find the decision that it wanted to reach, the court had to strike down previous efforts by Congress to regulate campaign spending. It had to strike down the constitutionality of McConnell. It had to strike down the constitutionality of the Austin case, both of which legitimized the right of Congress to limit the amount of money that found its way into our electoral system. In order to strike those things down, Kennedy had to reject outright any evidence that might exist that money corrupted the process. Basically what he's saying is, I don't see any evidence. And his point is the minority can't point to any evidence. What Justice Stevens does in his 90-page dissent is bring forth that evidence, is to illustrate by example instances in our history, in our recent history, where money bought elections. The example that becomes most prominent in Stevens's dissenting opinion is the West Virginia case of Caperton versus Massey Energy. And the buying of votes in order to place a friendly justice on the state Supreme Court in the state of West Virginia. Since I happen to live here, this particular case intrigues me. What I'd like to do, we've gone beyond the top of our first hour. It is now 6 minutes after the hour of 2 in the East. I'd like to take our 5-minute break and pause, and then when we come back, I want to look at the Stevens argument about Caperton versus Massey Coal as evidence of the extent to which money does corrupt. Recognizing all the while that what this does is make the case that Citizens United made the decision that it wanted to make. In other words, that the Supreme Court used the occasion of the Citizens United suit to make law. This is an example of judicial activism, clear and simple. And of course, as we know, it's conservatives who have always taken the position, traditionally taken the position, that the courts should not partake in judicial activism. Here they are, making law. When we come back, we'll look at this in more detail. It is now 7 minutes after the hour of 2, 7 minutes after the hour. Generally, we will take our 5-minute break and then we'll come back for the completion of our program in our second hour. This is Bill O'Brien for the Virtual Center for the Study of the Constitution and Civic Responsibility. Please stay with us. We'll be right back. Thank you, Bob Kincaid, and thank you, Bach, Johann Sebastian Bach, What a beautiful, relaxing piece that was. Thank you, Bob. Great way to start the week. That may be the highlight of our 2 hours today, Bob, but I appreciate it so very, very much.
Don't sell yourself short.
Okay, Bob, thanks. This is the Virtual Center for the Study of the Constitution and Civic Responsibility. We're into our second hour. I do invite your comments, and I invite you to take advantage of our phone access so that we can get you and your opinions and ideas and concerns on the air. Our phone number is area code 304-663-4676. 304-663-4676. My email address, if you'd like to react to some of these things directly via email with me, my email address is waobrien906@gmail.com. waobrien, O-B-R-I-E-N, 906@gmail.com. We were into the Citizens United decision, and more specifically, we are into the dissent in the Citizens United decision by Justice Stevens, the 90-page dissent. I had mentioned that in order to reach the decision that the court wanted to reach in Citizens United, Justice Kennedy, in the majority opinion, had to reject the existence of evidence to support the opponent's claim, the opponents to the decision claim, that money would corrupt. Kennedy points out in the majority opinion that while the implication and the assumption that it does indeed happen is there, the fact is, he points out in the majority opinion, hard evidence of quid pro quo where money buys influence is does not exist. Consequently, in his dissent, Justice Stevens had to take that particular position in the majority opinion on directly. And he does that by citing a case that I think most of us here in West Virginia are very familiar with, because as we speak, the state courts, the federal court here in West Virginia, is about to hear the case against Blankenship for his behavior prior to the deaths of 29 miners in the UBB disaster of 2012. Let me go to the Justice Stevens dissent in Citizens United. Quote, "The majority appears to think it decisive that the record does not contain, quote, direct examples of votes being exchanged for expenditures. It would have been quite remarkable if Congress had created a record detailing such behavior by its own members." In other words, Stevens points out in his dissent the obvious. Members of Congress are not going to leave written records which say, yeah, in this vote I was bought off. My vote was bought. There's no way you're going to find that kind of a record. So in a sense then, what Justice Kennedy is asserting in the majority opinion is something that's very difficult to refute, because the kind of evidence you need to do it doesn't exist. And Stevens points that out. Proving that a specific vote was exchanged for a specific expenditure has always been next to impossible. Elected officials have diverse motivations, and no one will acknowledge that he sold a vote. Yet, even if ingratiation and access are not corruption themselves, they are necessary prerequisites to it. They can create both the opportunity for and the appearance of quid pro quo arrangements. The influx of unlimited corporate money into the electoral realm also creates new opportunities for the mirror image of quid pro quo deals threats, both explicit and implicit. The insight that even technically independent expenditures can be corrupting in much the same way as direct contributions is bolstered by our decision, the court's decision last year, 2009, in Caperton versus A.T. Massey Coal Company. In that case, Don Blankenship, the chief executive officer of a corporation with a lawsuit pending before the West Virginia High Court, spent large sums on behalf of a particular candidate, Brent Benjamin, running for a seat on that court. In addition to contributing the $1,000 statutory maximum to Benjamin's campaign committee, Blankenship donated almost $2.5 million to, quote, "And for the Sake of the Kids," a 527 corporation that ran ads targeting Benjamin's opponent. In other words, Blankenship contributed what the law allowed, $1,000, to Brent Benjamin's campaign for the state Supreme Court in West Virginia. But he also funneled $2.5 million to an organization called And for the Sake of the Kids, which really was an organization aimed at running ads against Brent Benjamin's opponent. This is an example of the negative campaign ads that we've been hearing so much about since then and that we continue to hear about. Stevens goes on, this was not all. Blankenship spent, in addition, just over $500,000 on independent expenditures to support Brent Benjamin. Applying its common sense, this court accepted petitioner's argument that Blankenship's pivotal role in getting Justice Benjamin elected created a constitutionally intolerable probability of actual bias. When Benjamin later declined to recuse himself from the appeal by Blankenship's corporation. Though no bribe or criminal influence was involved, we recognize that Justice Benjamin would nevertheless feel a debt of gratitude to Blankenship for his extraordinary efforts to get him elected. The difficulties of inquiring into actual bias, we further noted, simply underscore the need for objective rules which will perforce turn on the appearance of bias rather than its actual existence. What Justice Stevens does is point to the court's decision a year earlier in 2009 in the Massey case to point out that the court at that time pointed out that the idea of quid pro quo buying of influence is never to be found, but that the circumstances surrounding such behavior are effectively within the purview of Congress to do something about. Stevens goes on about the importance of this particular decision. In Caperton, then, we accepted the premise that at least in some circumstances, independent expenditures on candidate elections will raise an intolerable specter of quid pro quo corruption. Indeed, this premise struck the court as so intuitive that it repeatedly referred to Blankenship's spending on behalf of Benjamin, spending that consisted of 99.97% independent expenditures of $3 million and 0.03% direct expenditures of $1,000 as a contribution. Obviously, the $3 million, even though it's direct, is going to have a lot more influence on the behavior of the recipient, even though it's indirect he's an indirect recipient, then will the $1,000 of direct campaign contributions. Let me go on. Blankenship contributed some $3 million to unseat the incumbent and replace him with Benjamin. Blankenship's campaign contributions had a significant and disproportionate influence on the electoral outcome. The reason the court so thoroughly conflated expenditures and contributions, one assumes, is that it realized that some expenditures may be functionally equivalent to contributions in the way they influence the outcome of a race, the way they are interpreted by the candidates and the public, and the way they taint the decisions that the office holder thereafter takes. Caperton, that particular case, Stevens says, is illuminating in several additional respects. It underscores the old insight that on account of the extreme difficulty of proving corruption, prophylactic measures reaching some, like campaign spending, not corrupt in purpose or effect, may nonetheless be required to guard against corruption. It underscores that certain restrictions on corporate electoral involvement may likewise be needed to hedge against circumvention of valid contribution limits. All members of the court agree that circumvention is a valid theory of corruption. It underscores that for-profit corporations associated with electioneering communications will often prefer to use non-profit conduits with misleading names, such as "and for the sake of the kids," to conceal their identity as the sponsor of those communications, thereby frustrating the utility of disclosure laws. That's a direct excerpt from the 90-page Stevens dissent in Citizens United. It points out the extent to which the election of a Supreme Court justice in West Virginia was more than likely, I'm thinking of the Deflategate case here, more likely than not, influenced by the $3 million that Blankenship directly contributed to this "And for the Kids" organization, which was committed to the defeat of Brent Benjamin's opponent. Obviously, then, the majority opinion written by Kennedy had to deny the reality of that connection in order to reach the decision that the majority wanted to reach in Citizens United. Let me point out one other feature of Citizens United that it seems to me is quite relevant in this whole issue. In other words, what we are pointing out here is evidence of self-interest because of the insidious relationship that has developed between government and those private for-profit organizations that ought to be and would be subject to government regulation of some sort. That's what Kolko's research in the 50s and 60s, leading to his Railroads and Regulation study in the early 1960s. That's what he was able to do, is establish the precedent for the insidious relationship between private sector and public sector that developed around the creation of the Interstate Commerce Commission in 1887 to regulate railroads, ostensibly consistent with government's responsibility to promote the public interest or the general welfare. But in reality, regulation that the corporations, the railroads, were much more able to withstand, since they were the ones who provided the detail of the regulatory legislation itself. One other feature of Citizens United is relevant in this, it seems to me, and that's the issue of the First Amendment and the whole issue of free speech. Traditionally, most people who have looked at the First Amendment focus principally on the speaker, on the fact that everybody, every person, has under the First Amendment the right to speak freely. The implication, therefore, is that the First Amendment free speech emphasis is on the speaker rather than the speech itself. Citizens United changes that. This appears in the concurring opinion in Citizens United written by Justice Scalia, Antonin Scalia. This is an excerpt from Scalia's concurring opinion in Citizens United, speaking about the meaning of the First Amendment. The amendment is written in terms of speech, not speakers. Its text offers no foothold for excluding any category of speaker, from single individuals to partnerships of individuals, to unincorporated associations of individuals, to incorporated associations of individuals. And the dissent offers no evidence about the original meaning of the text to support any such exclusion. We are therefore simply left with the question whether the speech at issue in this case is speech covered by the First Amendment. Unquote. What Justice Scalia is arguing, and this becomes part of the decision in Citizens United, is that the First Amendment protection of free speech focuses more on the speech than it does on the speaker. And Justice Scalia gives a variety of potential speakers, all of whom have the right to be heard. What this does then is open the door to the right of corporations to be interpreted as persons under the First Amendment. We know now with the Hobby Lobby decision that the personhood of corporations under the First Amendment has now been extended from free speech to religious freedom. In other words, the personhood of corporations is being pushed to the nth degree and endorsed by the majority, conservative majority on the Supreme Court, to award all the protections of the First Amendment that traditionally exist for human beings to corporations, to entities, incorporated or unincorporated organizations. Basically, by shifting the focus of the interpretation of the First Amendment from speaker to speech, what this does, what the Kennedy opinion does, and what Justice Scalia makes clear in his concurring opinion, is that if the First Amendment is really focusing on speech, then it would become a violation of the First Amendment for any law, state or federal, to inhibit free speech by anybody. If you try to prevent corporations from participating in political speech, according to this decision, you are violating the First Amendment to the Constitution. Stevens takes a lot of space in his dissenting opinion to go back to the founders and look at the way the founders looked at corporations at the time in the 18th century. The founders were very suspicious and very skeptical of corporations because of their power and their potential influence. Stevens's point is, it is ludicrous for the majority to conclude in Citizens United that the founders would have supported the right to free speech for corporations. That was the last thing that the founders would have endorsed because they were so suspicious of corporations because of their self-interest, at the same time that they were so protective of free speech. Basically then, the position of Citizens United, the majority opinion, is that the First Amendment focuses on speech more than the speaker. Consequently, the whole interpretation of the First Amendment from this perspective is that every legitimate avenue of speech needs to be protected in order that all relevant opinions are thrown into the marketplace of ideas. The assumption being that the truth will emerge only when all relevant speech is thrown into the pot. The assumption then, the conclusion, is that if you deny corporations the right to free speech under the First Amendment, you are effectively denying the general public, the public interest, a significant point of view which would be critical to the decision finally reached being the right one. The whole idea of political debate and discussion in the Republic, the implication here is, requires that all speech be on the table. And the only way to do that, then, is to interpret corporations as persons under the First Amendment in order to protect their right to free speech. In his dissent, then, Justice Stevens somehow needs to take on this particular point of view. And Justice Stevens does at the very outset of his defense, of his dissent. In fact, in the second paragraph, under the heading, Identity-Based Distinctions, Justice Stevens takes on this First Amendment emphasis on speech rather than on the speaker. I quote Justice John Paul Stevens' dissent. The second pillar of the court's opinion is its assertion, quote, that the government cannot restrict political speech based on the speaker's identity. If taken seriously, our colleague's assumption that the identity of a speaker has no relevance to the government's ability to regulate political speech would lead to some remarkable conclusions, Stevens said. In other words, what Stevens is saying is, if we take the majority's opinion literally here, if we agree with them that the First Amendment protects speech more than the speaker, then that's going to lead us to some pretty fantastic conclusions, Stevens has said. Such an assumption, for example, would have accorded the propaganda broadcast to our troops by Tokyo Rose during World War II the very same protection as speech by Allied commanders. In other words, if it was speech being protected, then our government would have to protect the right of Tokyo Rose to be on the air, as well as our own commanders. More pertinently, it would appear to afford the same protection to multinational corporations controlled by foreigners as to individual Americans. To do otherwise, after all, could enhance the relative voice of some over others. Under the majority's view, I suppose, it may be a First Amendment problem that corporations are not permitted to vote, given that voting is, among other things, a form of speech. In other words, Stevens he's pointing out the absurdity of the position, of the argument that Scalia makes. And what Stevens is saying here is, hell, if they're going to be persons and they're going to have the right to speak, why not give them the right to vote? Why not just let corporations vote and end it? Now, of course, we know that what corporations do is they take their position and make it very clear, and oftentimes they influence the members of that corporation, the employees who work for it, to vote in a certain way. I think that's one of the things we see in school bond referendums, for example, is that more often than not, when the turnout is light, bond referenda tend to pass because more often than not, the votes of teachers are able to sway the election, unless there's a lot of opposition campaigning to counteract that. We just had that situation this past Saturday here in an adjoining county here in West Virginia where a bond issue was soundly defeated, better than 2-1. In other words, the turnout, which is usually less than 10% in these kinds of elections, the turnout totaled 26%. And what that meant was that the opponents of the bond issue was so well informed and so well organized and so well prepared that they came out in force to offset the positive votes of teachers, and the bond issue did not pass. The point here, then, is to understand as best we can the thinking or the rationale in Citizens United. By defining or redefining the principal objective of the First Amendment of the Founders to protect speech, then by definition, you make it impossible to limit anyone's speech. Consequently, you can make the argument that corporations should have the right to speak because they have something to contribute to the decisions on the table. So therefore, the idea of corporate personhood under the First Amendment is ratified in the majority opinion. Citizens United has an incredible number of ramifications and important results. But let's go back, because we're moving toward the end of our program here. We are at 40 minutes after the hour right now. We have less than 20 minutes to go in today's program. Let's go back to the particular point that we made at the very beginning of the program, the major theme here. If, as the Brown and Williamson Memorandum makes clear, if the purpose of interest groups in areas in efforts to refute scientific evidence, if their strategy or the way they must operate is to create doubt, is to sell doubt, promote it, and thereby promote controversy, then what you are doing is intentionally confusing the general public, knowing full well that if you are successful in confusing the general public to the point that they can't tell fact from opinion, then what you have done is created the opportunity for the best structured, best funded, most frequently expressed, loudest voice to be heard. You make it possible for a confused general public to misinterpret opinion for fact. And thereby you render hard science much less effective, much less persuasive. This is the way Brown and Williamson laid out the strategy for corporations to take on the sciences, to take on fact, to take on truth. And the fact of the matter is, as often as not, perhaps maybe that's too generous, more often than not, government seems to fall for this. That ultimately, what the usual response is to turn back to the scientists and can you give us more evidence? Can you give us better evidence? Can you give us more documentation? Can you provide more proof? In the abstract, it's much easier for the corporation to come up with additional opinion than it is for the scientist to come up with additional hard evidence. And if you can't do that, then ultimately, in the general public's mind, opinion and fact become indistinguishable one from the other. Consequently, the argument with the most money, with the most financial backing, the most access to the media, the most access to Congress, the ability to buy influence becomes much more meaningful in winning the day. That's really what we've been seeing. That's what the Brown and Williamson tobacco wars were all about. Our friend in Baltimore, Harry, was kind enough to send a number of links to particular pieces of evidence which makes this point, drives this point home loud and clear. In our program last Wednesday, we talked about a New Yorker article written in 2012 by Jill Lepore of Harvard called The Lie Factory, which is the story of the creation of the first political consultant operation in 1934 in the person of Campaigns Incorporated, an organization created in California by two founders, Whitaker and Baxter, and their explanation as to how they were able to manipulate political opinion, to manipulate political consulting in such a way that they can make one candidate look good and the other one look bad in the eyes of the general public. This is the beginning of the massive amounts of money, the obscene amounts of money that find their way into our campaign system, into our electoral process. And last Wednesday, you'll recall that we looked at the techniques that they wrote about as presented to us by Jill Lepore in this article called The Lie Factory. If you go on the internet to the New Yorker 2012, Jill Lepore, you will find the article entitled The Lie Factory, which lays out the strategies, the techniques concocted by Whitaker and Baxter for Campaigns Incorporated And as Jill Lepore says, what they were writing was not just techniques, it became a rule book about how to win the public over, how to win votes, what you should do, what you shouldn't do, how to act, how not to act, what to tell the public, what not to tell the public. One of the things we found in that I think is so particularly alarming to me that it's worth repeating, is the following statement. Never explain anything. The more you have to explain, Whitaker said, the more difficult it is to win support. Say the same thing over and over again. We assume we have to get a voter's attention 7 times to make a sale, Whitaker said. Subtlety is your enemy. Words that lean on the mind are no good, according to Baxter. They must dent it. Simplify, simplify, simplify. A wall goes up, Whitaker warned, when you try to make Mr. and Mrs. Average American Citizen work or think. The whole campaign system is viewed by this political consulting firm as made up of a general public that doesn't want to think, that doesn't want to work, that doesn't want to do research, that doesn't want to do its homework, that is waiting to be told what is true and what's not, how to act and how not to act. So the role of the successful candidate is to tell John Q. Public exactly what he wants to hear or she wants to hear. That, in the person of Jill Lepore, in the New Yorker, is the application of the same kind of attack on truth that we've been looking at in science in our election system itself. If you think about this in combination with some of the things that Justice Stevens said in his Citizens United dissenting opinion, you can begin to realize why some of the things that most of us conclude are wrong with our political system, our campaign system, why they happen. You can begin to understand the rationale for Citizens United. You can begin to understand why corporations wanted a ruling from the Supreme Court that they got in Citizens United. They wanted their speech to be legitimate. The court gave it to them by reinterpreting the First Amendment to the Constitution to focus on speech rather than the speaker. I think that's a very interesting position that the majority of the Supreme Court takes. It's necessary in order to get corporations to the table, namely to be seen as persons under the First Amendment. However, one of the things that concerns I have, I didn't read this anyway, this is just my own, this is what I was thinking about this morning before we went on the air. If the First Amendment free speech part, if the free speech portion of the First Amendment, freedom of speech, focuses on the speech rather than on the speaker, what about religious freedom? Does religious freedom focus on the particular religion rather than on the people who practice it? Is the Supreme Court heading in the direction of an orthodox interpretation of religion that seems to meet the demands of the majority of people in this country? If you take the reasoning in Citizens United from speech and you shift it over to religion, you reach some very, very interesting possibilities and potential conclusions. Namely, that what you are doing is endorsing religion, provided potentially that it happens to be the right religion and not the wrong religion. Because you're not protecting the person in their exercise of religious freedom. Instead, you're focusing on the particular religion itself. I think that is full of problems if you think about that. We talked about tobacco. We talked about Brown and Williamson. We talked about the Supreme Court. We talked about Citizens United. And I think if we were to begin to pull some of this together, and I think we need to do that because we're down to about 6 or 7 minutes left in today's program, then it seems to me we are beginning to get, I believe, a much clearer picture of the principal dangers to our republic of Citizens United. I would suggest that the principal dangers to Citizens United is the surrender of political power in terms of our elections over to big money. People say that. People assume that. People allege that. But I don't see anybody proving that. I think we just did. I think that's the position that needs to be put in writing. I think what we did is create the ingredients of a very logical step-by-step process. If you believe this, and if you believe that, and if you argue this, and if you argue that, then these are the logical conclusions that one must reach. That what you are doing, then, is not seeking to inform the general public on issues. You are consciously seeking to confuse the general public on issues. In other words, what we're talking about here is free speech aimed not at education and knowing, but at miseducation and not knowing. Not at clarification and fact. But you are contributing to the ability or the tendency, if you will, of the general public to confuse opinion with fact. In effect, then, you are attacking the whole idea of truth in our society. You are basically saying that truth is whatever the person with the best argument and the loudest voice and the most money says it is. And you are so confusing the general public that you are making it impossible for them to refute that approach. We know it's wrong. I think at least what I set out to do today, and I hope I was able to do it, is to show why it's wrong, how it's wrong, and by implication, to indicate the need to find ways to overturn this decision. One comment on that, because I think there seems to be the groundswell of a movement in this country for the idea of a second convention, constitutional convention, in order to come up with an amendment, to the Constitution that would overturn or undo Citizens United. I would argue that we would be in danger there of a cure that's worse than the disease, namely the convening of an Article 5 constitutional convention. All the arguments we put forth against the idea of a convention, I think those advocating a convention to undo Citizens United need to be realistic, need to be politically realistic. Clearly, the reason that big money is moving the ALEC group, the American Legislative Exchange Council, and its supporters are moving towards the convening of a second convention is because they believe they have the votes and the power in the majority of states to get the amendments they want through. In the face of that, there's no way that an amendment to undo Citizens United has a chance. What we would be doing, it seems to me, is advocating a cure which would end up making the whole thing worse. We would create, by calling a convention, an opportunity for them to push their own agenda. We are at 58 minutes after the hour. I think it's about time to bring today's program to an end. I want to invite you to be with us again tomorrow here at the Virtual Center. Remember that we'll be beginning 1/2 hour later tomorrow than today, 1:30 in the East. For the Virtual Center for the Study of the Constitution and Civic Responsibility, for Bob Kincaid and the folks at the Head On Radio Network who were kind enough to produce today's program and are responsible for bringing it to you, I want to thank them. Mostly, I want to thank you for tuning in. I want to thank you for your continued support, and I want to invite you to come back for our next program. This is Bill O'Brien. Thank you so very, very much. Have a good day. Be safe, and we'll see you again tomorrow. Thank you.